you should know the claims that you're drafting. Second, most important, you should know the countries where you need to file much before you have actually even gotten the application to start drafting. Now, when I say about India, there are two things which are very, very peculiar, which largely come as a shocker to people at a later stage when they come for a national phase application. So there is a section in Indian patent practice, which is section 59, which talks about the fact that if you were to file an application, the national phase entry in India, with a particular set of claims, then later on, the only thing that you can do is certainly narrow it down. But unlike if I have to go and is the tool of sufficiency which is there in the disclosure. A lot of the times people assume what qualifies as disclosure or the level of disclosure in a patent application is pretty much same or harmonized, which actually is not the case. Europe has a different requirement. US has a certain requirement. India has a certain requirement. There is overlap, no doubt. But deciding upon, I do understand practically it may not be possible always, but having a first-hand information about which are the target countries where an applicant would likely be filing and knowing the laws, accordingly devising your application is certainly something that can save you a lot of money, that can save you rejections, and it could just be something that can also take you away from some of the shockers. So India doesn't allow a method for treatment claims. But regularly, when a national phase application comes, which is full of method of treatment claims, it's just a rejection that is being issued. The courts of late have now intervened, and they have allowed that much of leeway, so to say, saying that this was not really an applicant's fault, that they included only method of treatment claims, while their application or the disclosure also has some system or the composition limitations. So because they chose to first, they are US citizens or European citizens, they chose to file it out there first, and now they've entered India. Because the law requires in India that you can only go ahead and file as-is claims in national phase entry, there has to be a flexibility in Indian law that it should allow them to convert those method claims to system claims. However, if you look at the initial practice which was there, the practice actually has got a few rejections or refusals done. Yes, the courts are a very good friend of late, but can every applicant go and litigate is certainly a question. So I think knowing the law of the land, likelihood at the time when you're planning to file in a particular country is certainly helpful.